The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. We have a three-judge panel. Judge Rushing is on by audio, and Judge Motz and I are on with the video. And we'll proceed with the first two cases and then probably take a break as would be normal unless somebody wishes otherwise, and then continue with the last two cases. And the first case is United States versus Garcia. And Ms. Baldwin, we'll hear from you. I think you're first up.
Good morning, Your Honors. May it please the court. Melissa Baldwin on behalf of David Garcia. We are asking the court to hold that Mr. Garcia's Fourth Amendment rights were violated by an unreasonable traffic stop and an unreasonable automobile search. Here, the officer lacked a reasonable belief that Mr. Garcia, using the left lane to avoid a bump in the right lane, violated traffic law. Under North Carolina traffic law, a motorist is generally required to stay on the right half of a highway, subject to certain exceptions, including one for obstructions. Under this court's decision in United States versus Feliciana, that means the officer needed to articulate reasonable suspicion for believing that none of the exceptions authorizing use of the left lane applied. The officer had no such belief here. The officer knew that there was a visual but unmarked bump in the road that spanned the entire right lane that was significant enough to cause his car to bounce when he proceeded over it, and that Mr. Garcia used the left lane to avoid that bump safely and go immediately back into the right lane of travel.
Ms. Baldwin, this is Judge Rushing. Hi. Can I ask you, I wanted to ask a little bit about your reliance on Feliciana for this standard. In Feliciana, the violation wasn't visible, right? It was a permit case, so that the truck was required to have a permit, and an officer couldn't tell, watching the truck drive by, whether it had one or not. There was no requirement for the permit to be displayed. Whereas here, the officer could see the violation happening. And it would seem to me that distinguishes our precedent in Feliciana, that Feliciana's not saying officer has to rule out every possible legal excuse, but instead there the officer couldn't see the violation. Do you think that's a pertinent distinction here?
No, I do not, because in Feliciana, I would agree the ability to visually observe the crossing of the lane versus a permit is a factual difference. And so the application of the facts may differ, but the standard should be the same. And that's because just as it's wholly legal behavior to see for a commercial vehicle to be on a parkway, unless you have a basis to believe they don't have authorization by the permit, the same holds true here. If an officer sees someone crossing the lane, that is wholly innocent behavior unless he can articulate why no of the exceptions that render that behavior legal apply.
I don't think that's ever been how we've applied the law, right? It's not innocent behavior. It violates the law to go into the other lane. And we've never said an officer has to rule out every legal excuse.
Well, I would disagree with that. It is innocent behavior if you cross into the left lane under one of the exceptions that authorizes that. So simply seeing someone use the left lane is wholly innocent conduct unless the officer can point to evidence suggesting the exceptions don't apply. And indeed, 3 state courts that have dealt with similar maintaining the right half of a highway have specified these 2 factors. The officer both needs to see the vehicle crossing into the left lane and have a basis to believe none of the exceptions apply, or there's not some other legitimate factor such as road conditions. And that is the Edwards case out of Maryland, the Davis case out of Tennessee, and the Chavez versus Ibarra case out of Kansas. So here the officer was well aware that there was a bump in the road that constituted an obstruction. It made it made either the road less safe or convenient, or it slowed the progression thereof. And as a result, he knew there was an obstruction, and he knew Mr. Garcia used the left lane to avoid that obstruction. Under these circumstances, the officer didn't have a reasonable belief that he was violating the law by using the left lane to avoid an obstruction, as the North Carolina traffic statute expressly permits.
Well, I thought that there was testimony. Hi, this is Judge Mons. I thought there was testimony that the supervisor said that this, or some witness said that this was smaller than a speed bump.
So the supervisor gave testimony, but smaller than a speed bump could be, a speed hump, which is a traffic control device, not quite with a raise, not quite as much as a speed bump, but nonetheless is a traffic control device designed to slow traffic. In other words, an obstruction.
But you don't have to avoid it.
Oh, so you don't have to avoid it. Of course, if an officer sees a motorist avoiding a clearly delineated traffic control device, that is surely different than seeing an unmarked one.
You've looked at the picture, haven't you, from the police vehicle? It looked to me like an absolutely normal highway patch, and every patch is usually raised by an inch or so they don't depress when the weather gets warm and the tar gets pressed down. But I must say, if I were a driver, I might have slowed down a little bit on the patch until I see how whether it was anything, but the picture showed it as a very normal highway patch. I would hardly call that an obstruction. At least we don't have to conclusively determine that. We just have to determine whether the officer reasonably concluded that it was not an obstruction.
Sure, Judge Niemeyer, and your questioning brings up two important points, and it's why the traffic stop was unreasonable here, and that's because the government didn't offer evidence of the experience. I mean, if the officer had testified, listen, I patrolled the area, I've seen 150 cars go past this thing in the last 2 weeks.
All we need to use is some common sense. I looked at the picture. And I must say, I'm a driver like anybody else, and I can bring to bear the experiences that everybody brings on the road. And that was not what I would call, in common parlance, an obstruction. It was at best a minor rise with respect to a patch. But as Judge Mott said, it wasn't even a speed bump, and speed bumps are legitimate. You slow down to go over them. But this was not even close to that. This was basically just a flat patch in the highway, and the officer said he went across it normally. He didn't hesitate to go across it, and sure, there was a little rumble as you go up and down it, but I think your elevation of that little piece of highway to the word obstruction is pretty tough in view of the officer's own belief that he didn't think it was an obstruction. And our determination isn't whether it was or not, but whether he had a reasonable take on that.
Sure. Well, a couple points. The officer never testified as to his belief as to whether or not it was an obstruction. And second of all, the evidence here does suggest the highway maintenance supervisor acknowledged this was, quote, not a bad bump, and you would do as you go across it, and the video shows it bouncing. So whether or not, and so here the problem is all they had was the officer drove over it, but that doesn't tell us anything about whether it was necessary for Mr. Garcia to go over it. Necessary is needed, and it triggers a context-specific inquiry, which gets us to the cases of Gregory versus Freeman from the 6th and 10th circuits, where they acknowledge that these traffic laws that include a context-specific inquiry to determine if there's a violation. In those cases, it was staying as practically as possible in your lane, in a single lane of traffic. They said, listen, you can't just cite someone for deviating from their lane as a violation of practically as possible, because in those cases, it was a windy road or it was a top-heavy vehicle and slight deviations. And so here we have the same thing where we have a visually obvious we have a visually obvious thing in the road that the record establishes would slow, hinder, impede. It would have an impact on traveling vehicles. And the government could have presented evidence to show that an officer reasonably believed this violated the law, but it didn't do so. The officer simply pointed to the fact he crossed the left lane, which is entirely legal if an exception doesn't apply, and the fact he drove over it. But a hallmark of reasonable suspicion to pull someone over is that it can't ensnare a substantial amount of innocent innocent motorists. And traffic laws are full of these context-specific inquiries, this obstruction, a speed no greater than reasonable under current conditions, distance from keeping a safe distance from the car in front of you. All of these
So this was a double yellow line, and the double yellow lines, every driver knows, is a warning that it's unsafe to be in the other lane. There may be a curve right up ahead, or there may be blocked vision. And so it's no small thing to cross over a double solid line. And I just don't think the burden is to demonstrate that the officer acted unreasonably, didn't have reasonable belief to believe that it was illegal to cross the double line. And you're saying, well, we'll measure the height of the hump, we'll measure how many people went across it. It wasn't even a hump, it was a patch with raised asphalt, because if you put in the asphalt exactly level with the highway, within a couple of weeks, the asphalt would have been depressed and it created a bump the other way. Would that be an obstruction?
Yes, it could be. I think there would be need to be more facts to pull someone over.
Right.
And going back to the exception of crossing the double line could be dangerous, sure, it could. But the problem is here, the officer testified that it was safe to cross the yellow lines in this circumstance. And of course, you know, the canon of construction, the more specific controls over the general. So if there's an obstruction in the road, then you're permitted to cross those lines to avoid it. Otherwise, the exception is authorizing drivers to do something that the more general statute would prohibit. And so now I'd like to turn to the automobile search here, because the officers lacked a basis to either perform a Gantt evidentiary search, because they had no reasonable suspicion that evidence relevant to the offense of arrest would be present in the vehicle. So here the offense of arrest was for carrying concealed brass knuckles. The officers had no reasonable belief that evidence related to Mr. Garcia's possession of the brass knuckles would be in the car. As the North Carolina McZorn case said, once the officer frisked Mr. Garcia and found those brass knuckles, he had absolute knowledge that this crime was committed. And thus it falls in line with the 11th.
Wouldn't it be fairer to the officer to give him the full benefit of what he saw? In other words, he saw the brass knuckles, he saw a knife, he saw a vest, he knew of the destination. This guy had an open warrant against him. We're at 2 o'clock in the morning, and he's going to a location where there's a domestic spat of some kind. And the question then is, he was arrested both for having the brass knuckles and for the warrant. And the question is, okay, what other kind of arms are in there supporting that? I would assume that you see a person in those circumstances, you could well suppose that there are further arms in the car.
Well, Judge,
I would think the more difficult hill you have to climb is the probable cause issue. But you can go ahead with however you wish to present it.
No, certainly. So I wanted to make that point just about, you know, the lack of evidence relevant to the offense of arrest. But of course, if there's probable cause to search the vehicle, you don't need to rely on Gantt. And here, if they're looking for other weapons, so other crimes than the one for which they had probable cause to arrest Mr. Garcia, they needed probable cause. And here, the totality of the circumstances did not give rise to a reasonable belief that other weapons would be found in the car. And that's because there is nothing to support the idea that where there's some weapons, there must be more weapons. The government—
It doesn't have to be must more. Question is probable cause is a much lower standard than must. It's not even, it's what a reasonable officer with the experience he have would believe. And I would think it's pretty normal for an officer to see one weapon, that there may be other weapons, there may be ammunition, there may be a gun. This guy was not allowed to carry a gun. I mean, he doesn't have to put blinders on. He just has to act reasonably.
I mean, he doesn't have to put blinders on, but the idea that because he found 2 brass knuckles in pockets reasonably leads to the conclusion that—
Let's add the knife, and let's add the vest, and let's add all the other things that he's putting in there. This officer sees a picture, and the question is, what conclusions can he reasonably draw from that picture? And the only fair way to argue it is to give him the benefit of all that.
So, well, I'm coming from that perspective because I think all those other factors, they are indeed relevant, but the fact he was going to assist as a friend with an aggressor, he had a vest on, he had a knife, at most that rises to reasonable suspicion of guns. So the finding of the brass knuckles can only transform the reasonable suspicion into that he may be armed into probable cause to search the vehicle for other weapons is if an officer can reasonably conclude that some guns equals more guns. And we believe the Supreme Court case in Messerschmitt shows that it is not a rational legal inference to say because there are some weapons, there are going to be more weapons. The officers here needed to do more to establish probable cause to look for more weapons. I see my time is up, so I will—
Okay, thank you. You have some rebuttal, and we'll bring you back. All right, Mr. Enright.
Thank you, Your Honor. May it please the court. Anthony Enright for the United States. The district court properly denied David Joe Garcia's motion to suppress. I'll start saying the Fourth Amendment authorized Sergeant Warren to stop Mr. Garcia's Nissan after he observed Garcia driving to the oncoming lane of traffic. The district court made a factual finding that there was no obstruction caused by the black asphalt paving patch. And I think the question for this court, or at least a basic question for this court, would be, is that clearly erroneous? And I think the answer is no. He had testimony from the person who was responsible for installing that patch and who was thoroughly familiar with that, the highway maintenance supervisor. And he testified, A, it's not an obstruction. B, it was put there to, quote, make sure the road was safe for travel and wasn't impeding traffic, which is the ordinary definition of an obstruction. It says it was just a little bit of a rise. And that's, of course, not all that the officer had. The officer saw it for himself, as Judge Niemeyer alluded to. Or, I'm sorry, the court saw it for itself, because the court saw the video and the photograph. And he heard Sergeant Warren testify that he drove over it, and he saw the dash cam of that event. The district court was well within its authority as a fact finder to find it wasn't an obstruction. But even the court doesn't even need to go that far, because the standard is, as Your Honors mentioned, reasonable suspicion, considerably less than proof beyond a reasonable doubt, considerably less even than a preponderance of the evidence or probable cause. Sergeant Warren observed the entire offense. He observed him go into the other traffic lane, and he observed what Garcia later said was the reason for going into the other lane. And he had reason to, he had objective facts creating more than a hunch that he committed the traffic violation, violated the rule requiring him to stay in the right lane. And that justifies the stop under the Fourth Amendment. After he stopped Mr. Garcia, he had two justifications under the Fourth Amendment to search the car. The first is probable cause. And as Judge Niemeyer alluded to, the facts amply establish probable cause. This court held he was carrying contraband, illegally concealed weapons. The officer knew that before he searched the car. And this court did hold in Baker that the probable cause standard is satisfied when a police officer lawfully searches a vehicle's recent occupant and finds contraband on his person. But the court doesn't need to, that's just the beginning. He gave the officer information indicating he was going to go confront somebody in the middle of the night who was harassing a friend. And he was armed with illegal weapons and a knife. He was on supervised release for a gun offense, and he was wearing a tactical ballistic vest. Officer had reason to believe there was more than a fair or probable cause, in the sense of more than a fair probability, which is all that it requires, to believe that there would be additional concealed weapons or other contraband or evidence of those crimes found in the car. But the court doesn't need to go that far because, as
Let me ask you a question. He had a tactical vest, and the vest had pockets to put in what the Kevlar protective shields or whatever they are. Are they legal for the public to have, or do you need a permit, or is that okay to wear a vest?
Your Honor, I'm honestly not 100% sure. My understanding is that it probably ordinarily is okay. And I can tell you, I'm not speaking based on the record in this case. There was no testimony in this case or indication that that was illegal, with or without a plate in this case. Based on what I'm admitting is not very good knowledge from outside this case, I think the answer is those are ordinarily legal in North Carolina. But
well, my question really would lead to the question of the vest is indicative of something. This was not a keep warm vest. This was a vest designed to protect somebody from harm during some kind of combat or something.
That is exactly right.
And the question would be is whether a search might have uncovered the plates that are insertable in that. But if the plates are not illegal to have, that wouldn't carry as much weight.
Your Honor, I can see that's a totally fair point that I simply didn't think about until Your Honor mentioned it. I don't think the court needs to go that far because he didn't just have the vest, but he had circumstances indicating that he was wearing that vest for a potentially an armed confrontation. He also had illegal weapons on him. And this court, the Gantt rule, which is that you can search a car if a recent occupant was arrested for evidence relevant to the crime of arrest. What Gantt did was it said we're adopting the concurring opinion of Justice Scalia and Thornton. Thornton involved a very similar scenario where someone was arrested and they had contraband on him. It was drugs. And what Justice Scalia said, what he concluded Thornton with, is petitioner was lawfully arrested for a drug offense. It was reasonable for Officer Nichols to believe that further contraband or similar evidence relevant to the crime for which he had been arrested might be found in the vehicle. I think that answers the question of whether that standard would allow you to search for additional weapons. That's true, I think, whether you would consider the crime complete with possession of brass knuckles or not, because the Supreme Court in Gantt explicitly adopted in toto Justice Scalia's concurring opinion, which says you can search for additional contraband, at least of the same kind. But either way, I don't think the court needs to go resolve that question because the evidence is, as Judge Niemeyer mentioned, is well beyond simple possession of a concealed weapon. These were circumstances that indicated to an objectively reasonable officer that there would be evidence of a crime found in the car, there would probably be evidence found in the car, and that is all that is needed when you're searching an automobile to comply with the Fourth Amendment. So because the district court correctly found that the Sergeant Warren complied with the Fourth Amendment when he conducted the search, it properly denied the motion to suppress. And if the court has no further questions.
All right. Thank you, Mr. Enright. Ms. Baldwin?
Thank you, Your Honor.
Thank you, Your Honor. So a couple of points I want to address is, first, the government's reliance on United States versus Baker. And its reliance is misplaced because there the court was facing a Sixth Amendment ineffective assistance of counsel. This is a Fourth Amendment case. In other words, the statement made in Baker that wasn't essential to its holding is actually at issue here, and the parties have briefed and argued it. So simply relying on that statement should not be enough here. And second of all, going back to Gant and the idea that finding contraband necessarily means there's going to be more. And again, I think there's certainly much more support for that in the drug specific context, but the government hasn't cited, but the, excuse me, but the weapons rationale or analogy is not the same. And we know that because of Messerschmitt. If it was as simple as like, listen, we know this gang member has one gun, so you can look at his home for other guns, there wouldn't have been this fractured, contentious case where the court explicitly noted, we're not even saying there was probable cause. We're saying the fact this was a gang member who tried to kill his girlfriend, and we know he had one gun, it wasn't unreasonable for them to rely on a warrant to search for other guns. So it is certainly shouldn't the presumption that some cases hold where some drugs equals more drugs certainly shouldn't be extended to the weapons case. Again, the government could have offered evidence if it is so common sense that, you know, listen, we found some weapons. That means there's probably going to be more weapons. The government should be able to elicit that testimony.
But I'm not sure that's the logical sequence that the reasonable officer would follow. The reasonable officer is looking at this situation that in the middle of the night, this man is being called into a potentially violent dispute. He's armed with knuckles. He's had a past record of having firearms. He's not allowed to have firearms. He has a large knife. He has a vest, a tactical vest. I think it's perfectly reasonable to assume that the rest of the arms are in the car. The rest of the arms being, do you go into a combat with just knuckles? Or do you go in with some better arms? And this guy knows street fighting and so forth involves arms. That's a scenario he's thinking. It's not of necessity. It's a question of it's reasonable. Is it reasonably a probable cause? And we necessarily mean there's another arm. You're absolutely right. Absolutely right on that. But I'm not sure that's the mental process, and it certainly isn't the standard.
Pulls over someone, he knows it's on probation for theft, en route to a pawn store, finds a stolen ring and a stolen watch. That doesn't give him a reasonable belief there will be more stolen property in the car. But I have a short amount of time and I want to go back to the traffic stop because the government's contention that the obstruction is clearly erroneous, we believe is wrong. The testimony shows that the maintenance supervisor was basing his testimony on a legally wrong definition of obstruction, which is, does it endanger the public, which is much higher than even the government contends it legally is. So under Boyce Corporation and Pullman standard, that factual finding can be set alone on that basis alone because it's infected by a legal error. And here, again, the objective facts are simply that he crossed the line and the officer didn't. But as we pointed out, that is going to ensnare, I'm sorry, may I just finish my thought?
Yes, please.
That is going to ensnare a substantial amount of motorists if there is a traffic law permitting discretionary decisions based on road conditions and the motorist simply made a different call than the officer. For those reasons, we ask that you reverse the suppression order, vacate the conviction, and remand this case. Thank you.
All right, thank you, Ms. Baldwin. You know, in the normal procedure now, we get off the bench and we come down into the well of the court and shake hands with you. Thank you for your arguments. And we do that virtually now. And thank you both for your arguments and wish you a best day. We'll proceed on to the next case.
Thank you, Your Honor.
Thank you, Your Honor.
South Carolina Department of Social Services. This is what I call, or otherwise, a Greek tragedy. But let's hear from Mr. Richter first.
Good morning, judges. May it please the court, Ronnie Richter on behalf of the appellants Michael and Heather Livingston. We're here today because the district court abused its discretion under Rule 59E and effectively served as its own court of appeals in reversing its original denial of summary judgment in this case and ultimately granting summary judgment. We're asking the court to reverse that order and remand this case back for trial. The case is a procedural odd duck. On June 20th, 2019, there was a report and recommendation after a very well-developed record in this case with lots of deposition testimony, voluminous submissions to the court. And the magistrate made a report and recommendation to the district judge recommending summary judgment be granted in this case. An important thing happened after that report and recommendation, and that is this court issued its opinion in Gilliam versus Shealy. And we supplied the court with a supplemental brief prior to its ruling on its first order for summary judgment. On September 20th, 2019, 3 months after receiving the report and recommendation, the court entered a very well-reasoned, lengthy order denying summary judgment, adopting most of the arguments that we'll make to this panel today. And subsequently, under apparently the authority of Rule 59E, several months later in February of 2020, that same district court judge reversed itself a literal 180 of the positions that were taken in the first order. Your Honors, we believe that the court erred in 3 material respects that we would like to address to you.
Sir, excuse me, before you get there, maybe you can tell me, without making an assessment whether that's legal or not, tell me, did anything happen? Was there a hearing? Was there an additional piece of an additional fact put in the record? Were there new law put into the court?
No, Your Honor.
Nothing happened.
Not from our perspective.
I'm not asking about your perspective. I'm asking about what happened. Period.
No, there were no evidentiary supplements to the record. There was no change in the case law authority. The Gilliam case was the change in authority, but that case issued before the first summary judgment order, and that case is addressed in the first summary judgment order.
Was there were there papers filed, legal papers filed by the sides?
There was a motions for reconsideration under Rule 59 were filed by the respondents, and those matters were briefed to the court. We took the position that there is nothing new here. There's no new evidence. There's no change of law. There's no reason for the court to revisit an already well-considered order that issued the first time.
Let me ask you something. 59 applies to judgments, does it?
Yes. Yes, Your Honor.
There was no judgment, was there?
Your Honor, I'm not sure the answer to that question. There was certainly—
You know the answer to the question. It was not a judgment. It wasn't final. It was a ruling saying we're going to go ahead and try this case.
That is correct. The ruling—
Okay, that's not a judgment.
Yes, sir.
That's a ruling on a matter of law, and the court changed its mind. Now, is there any problem with the court realizing it didn't do what it wanted to do, or it made an error of law that it can't correct itself before judgment?
I think
That's an extraordinary proposition.
I think there is, Your Honor, in this sense. The authority that was—
Well, it's not 59, then. You got to find me some other authority, because a judge makes a ruling in a trial and leaves out some evidence. Then he says later, and this happens a lot, he says later, I made an error on that. I'm going to let that in, and or vice versa. I'm going to exclude it. And then he instructs the jury. He's changed his mind about it. He's trying to reach the right result in good faith. Now, you're saying we have to lock judges into their initial takes on any kind of ruling during the course of a trial?
Well, no, Your Honor, I'm not suggesting that. I'm suggesting that the parameters of Rule 59E are pretty well laid out as to the—
But 59E, you just conceded, doesn't apply. We're talking about an order, an interlocutory order entered in a case saying we're going to proceed to trial. And then the judge later saying we don't need to proceed to trial.
Well, Your Honor, the issue, I agree with exactly with what you're saying, except that the authority that she cites for the proposition that she was permitted to do what she did was Rule 59E, and we believe that
Well,
that was
maybe that's
an
error
unconstitutional
too.
rule.
I mean, that doesn't mean it is, just because, do you agree with everything that the other side says?
No, of course
No.
not.
I think we do much better to get to the merits of this thing, but I'll leave the argument up to you.
Well, I'm happy to go to the merits, Your Honor. If we look at the merits of what was done in those two orders, again, we take exception with her ability to revisit it under 59E, but having revisited it, she revisited.
But okay, you're persisting in that, and that's your privilege. Take me through the argument of why 59E applies.
Your Honor, 59E does not apply.
Well, then why are you saying she violated the standard of 59E?
I'm saying that she violated the standard of 59E because it's limited to circumstances where there's been a change of law, there's new evidence, or there's a basis to correct an error to avoid.
I know, but is that relevant if 59E doesn't apply? Is any of that relevant?
Your Honor, it's only relevant in the sense that it's an abuse of discretion standard, and it's our position that she abused that discretion by taking action under the apparent authority of that rule that she was not authorized to take.
Why wasn't she authorized to change her mind? What principle of law says a judge who makes a ruling, an interlocutory ruling during the course of a trial or the proceedings leading to a trial, can't change its mind? The court can say, I'm going to exclude these witnesses. And the lawyer comes back and says, hold it. I really need these other witnesses. I want to lay on some more evidence to the jury. And the judge says, well, I'm going to let you do one more witness. Can't he do that? Or she?
Well, Your Honor,
I mean, this happens daily. I was the district judge, and I can't tell you how many times I changed my mind on things during the course of proceedings. You see things from different vantage points. You see the lawyer didn't have as fulsome an argument. You say, well, maybe you have a point there. A good judge has to react to try to get to the right result and produce a fair trial. And during the course of that, if he makes an interlocutory temporary ruling pre-judgment during the course of the trial, he's got to be able to reverse himself, or she's got to be able to reverse herself if she thought it was wrong.
Your Honor, I certainly respect the court's point of view on that. I don't believe.
Well, give me some law that says they can't do that.
I cannot, Your Honor. I cannot. I believe the authority is under 59E. I think the case law is clear on what it affords a court to do and not to do. But I'm also equally convinced that I'm not going to change your mind about that. I'm not trying to pigeonhole judges.
No, yeah, you would change my mind if you had some law or some persuasive argument, but you have conceded that 59E doesn't apply. And so I'm asking you what rule or what principle applies that a judge can't change his mind during the course of a trial.
And I can't cite you authority that says that, Your Honor.
Okay, well, why don't you go ahead then and talk about the rest of your argument?
Yeah, so having revisited her order, in the first order, she addressed the Gilliam case, which we think is on point and dispositive of the issue before the court. And in her first visit to the Gilliam Cook case, she ordered that the Fourth Circuit has recently spoken about the use of the exclusionary rule regarding coerced confessions. Whether a confession is involuntary is a question of fact to be determined by the totality of all of the circumstances, both the characteristics of the accused and the details of the interrogation. Therefore, the allegedly coerced confession cannot be used to determine the issue of probable cause in the report.
Can I ask you about that?
Yes.
You make a powerful argument about the conduct of the sheriff. It actually provokes, a strong reaction when you see a sheriff continue to question after somebody's asked for counsel and then tries to manipulate around it and doesn't give them Miranda rights and all those things. But we have a probable cause hearing before a magistrate of some kind, and he testifies before that person under oath and says basically the same things he said to the sheriff. Now, why isn't that a legitimate part of the record?
Your Honor, that is a part of the record, and that hearing was in the family court.
Family court judge, But
Sure.
why, he's standing in the family court, and was he under oath?
He was under oath.
And so he testifies and he says all the same things.
Your Honor, the test for the probable cause that we're here to evaluate is what was known to the officers at the time of the arrest. Obviously, that's well after the arrest. So did they have probable cause at the time of the arrest of Michael Livingston? And they did not, absent his coerced confession.
Why not? You come to the hospital with a baby who has broken ribs, old healing of broken ribs, current broken ribs, broken skull, and both parents say there's been nobody else in the house, they suggest that this is indicative of child abuse. They put it all together. It's a pretty troubling fact presentation. Unfortunately, it turned out to be untrue, as you know. He's trying to provide an explanation of how that occurred. He's not saying I did it. He's saying basically, well, the baby was colically and I held the baby. Maybe I held him too tight, or maybe the head hit the side here or something. He is trying to be helpful, but all of that basically is trying to take the blame so that his wife doesn't get blamed. But the only two people that are suspects are Michael and Heather, right?
That's not exactly, no, there is the child Hannah, who's a 9-year-old in the household as well. That's also known, and there's actually a threat by the officers that we're going to interrogate Heather. And Your Honor, your point is well taken that this is a factual inquiry, and the issue on probable cause is based upon an objective standard, not subjectively what the officers believed at the time was a reasonable basis for them to believe there was probable cause without the coerced confession. And the record is replete with evidence that would suggest that there was not probable cause without the coerced confession.
Well,
For
how
example,
would it take all that other evidence?
I'm sorry?
How we to take all the other evidence? The husband presents a baby into the hospital with a broken skull, and then they find multiple injuries that occurred over differing times around the ribs.
Your Honor, you're
What
to take that
are we supposed to? How is the sheriff and the public authority supposed to react to that?
They're supposed to undertake an investigation. In the
And they did, and it wasn't resolved. There was no explanation that detracted from Michael.
Well, Your Honor, even that point of view, which is repeated in the court's second order, to find that the parents could not offer a plausible explanation at a summary judgment standard is not evidence of guilt. It's evidence of innocence.
No, we're looking at probable cause for the arrest because the charges were filed following probable cause created by a court. So the only probable cause issue that you can argue is the arrest.
That's
And
correct.
the arrest issue is based on what the officers had in hand when they made the arrest.
Well, this is what the entire factual record would say about that. The first time the children were examined, nothing was revealed. The first time DSS and police came to the emergency room, they left and the case was closed at 4:35 p.m. When Dr. Lubroff first examined the children, her examination confirmed injury, yes. She added a layer to that by saying it appears non-accidental. That there's nothing about that that says Michael Livingston hurt his children. There's 4 billion people in the world. So an investigation has to start, and an investigation does start. No arrests are made at the hospital. No arrests are made, period, until Michael Livingston offers his coerced confession. Heather Livingston is examined first. No arrests are made. Michael Livingston is interrogated. He asks for, he invokes his right to counsel. Some gamesmanship is played about the telephone and his access to counsel. When he can't find counsel, the examination recommences. He's not re-Mirandized. No arrests are made. No action is taken to arrest anyone until such time as Michael confesses. And the testimony in the case was from Officer Preston that but for that coerced confession, a thorough investigation would have followed that would have included things like interviewing the physicians, interviewing the pediatricians, interviewing others who had access to the children. That did not happen. When the matter was referred over to the magistrate for arrest warrants, the probable cause that was stated was Dr. Luberoff's report and Michael Livingston's coerced confession. The facts in the case indicate that but for that coerced confession, there was insufficient evidence to make an arrest. Those are what the facts indicate. It's a summary judgment standard. I apologize, I'm over my time. You know, inferring the facts in favor of the plaintiff, the only reasonable conclusion that could be made here is that we have a factual dispute that has to be submitted to the jury on that issue.
Let me just ask you one question before, because I'm going to raise it to the other side. The district court didn't rely on any immunity, did they? Qualified or absolute immunities?
No, sir, Your Honor.
Were they raised by the defendants below?
Yes, they were raised.
All right. Okay, thank you.
Thank you.
All right. Who do we have up next here? Mr. Lindeman, are you next?
I am, Your Honor.
Okay, why don't you proceed?
Thank you, Your Honor. May it please the court, my name's Andrew Lindeman. I'm representing several of the appellees, the 3 Richland County Sheriff's deputies, as well as the Richland County Sheriff's Department. My colleague, Mr. Gessner, who has 5 minutes after I am through, represents the South Carolina Department of Social Services, who is also an appellee in this case. Real briefly on that threshold procedural issue, and I think that's probably been discussed enough, but just to make a couple of points. Number one, the issue that's on appeal in this case is an interlocutory order. That's without question. Ultimately, or the initial ruling, excuse me, was an interlocutory order by Judge Childs. It granted in part and denied in part the summary judgment motion. So it was interlocutory. Clearly, there's precedent from this this court, the American Canoe Association versus Murphy Farms.
Yeah, but see, that's inapplicable too. That doesn't make any difference. You know, the order that we're looking at is the early order that the judge denied the summary judgment motion. That's the order where she changed her mind.
That's correct, Your Honor.
All right, now the question is she allowed to change her mind with respect to that order? That's not the certified order. I mean,
Right.
you get into a lot of complexities when you start talking about Rule 54B or 1292B and the nature of those orders, whether they are judgments and our review of those. But we're not there. We're at an interlocutory order entered in the early part of a judicial proceeding, and the court changes her mind on it.
And there's clear precedent, Your Honor, as you were discussing with opposing counsel, that allows a trial court to revisit and reconsider an interlocutory order. There are numerous.
Your colleague on the other side said you relied on the rule, and that's why he was talking about the rule. But the rule isn't applicable, right? Are we all in agreement now? Because this is an interlocutory appeal.
Right. Technically, 59E was not the appropriate standard. It was Rule 54B, which specifically says that interlocutory.
It wasn't Rule 54B.
It wasn't.
Okay.
54B talks about certifying an order for appeal. That's the second order that the judge entered. What we're talking about is, can the judge change her first order? Her first order was a procedural order saying we're going to trial. And they're not going to dispose of this on summary judgment. And the question is, can she change her mind on that order?
And there's clear precedent that allows that with an interlocutory order, Your Honor. Let me move to
It isn't an order. It's just a ruling, like an evidentiary ruling. Haven't you ever been in a case when the court says, no, I'm not going to let it in, and then and the court says, well, I think I will let it in?
That's correct.
None of those are appealable under any Rule 59 or 54 or anything else.
Well, and Your Honor is exactly correct. I mean, it is an interlocutory ruling by the court, so it's always subject to correction or change up until the time of final judgment. And ultimately, that's what occurred in this particular case.
I would appreciate it if sometime in your argument you can get to the argument that your colleague on the other side ended up with, which is whether there was probable cause without this statement from the father.
Absolutely. And actually, I was heading right there. In essence, this entire issue regarding the allegedly coerced confession and whether or not the application of the exclusionary rule applies in a Section 1983 case. Obviously, all of those legal issues are raised and before the court, but the court doesn't even need to reach that issue because ultimately, as the district court ruled, even absent the confession itself, there was sufficient evidence that was developed at the hospital before Mr. and Mrs. Livingston were even transported to the sheriff's department for interrogation. There was sufficient evidence that was developed at the hospital that would provide probable cause for the arrest under the child abuse statute. And in a nutshell, those are several different points. Number one, the actual child that was brought in for medical treatment was diagnosed with a skull fracture. Ultimately, it was determined that the child also had a number of broken ribs, both old and new. Then there was a request that his twin brother be brought in. The twin brother was brought into the hospital and was examined. And ultimately, it was determined that the twin brother also had fractured ribs. So you had very similar injuries to both of the twin infants. The twin infants were both examined by two different physicians. The emergency room physician, Dr. Donahue, offered the opinion that the injuries were not accidental, that they were caused by specifically caused by non-accidental trauma. And then ultimately they called in a child abuse specialist who was Dr. Susan Luberoff, who is also a defendant in this case, even though she's not part of this appeal. And she examined as well, issued a report, and in her report she says the child's injuries are not explained and are most consistent with non-accidental trauma. That report was available and provided to the law enforcement officers as well as DSS prior to the interrogation of Mr. and Mrs. Livingston. Neither parent, it is undisputed, neither parent could offer any explanation for the injuries to either medical personnel or to law enforcement authorities. They cannot provide any type of explanation. And lastly, they were the only conceivable caregivers by their own admission. In fact, both ultimately testified that the 9-year-old daughter, Hannah, that the two twins were too young, that she didn't participate at all in their care. So the only caregivers, it was undisputed, were the two parents. So ultimately, that information provided probable cause for the arrest of Michael Livingston under the South Carolina Child Abuse Statute without even any consideration of the confession itself. And quite frankly, that's as far as I would submit that this court needs to go with that issue. That is a determination that was made by the district court, and there was sufficient evidence, as just described, to support that. Those historical facts are not disputed by the appellants. The record includes Dr. Luberoff's report, which includes the exact language that I just quoted to the court. The appellants argue that the deputies did not believe they had sufficient evidence for probable cause because they proceeded to interrogate the two parents and obtain a confession from Mr. Livingston. Of course, it is well settled, and the district court mentions this as well, that the subjective beliefs of the officers are totally immaterial. It is purely an objective standard, and applying the objective standard to those historical facts that I just outlined clearly showed that there was probable cause. In addition to that, the appellant's own law enforcement expert, James Burgess, testified that in his opinion, Dr. Luberoff's opinions, particularly given the fact that she was a child abuse expert, someone called in specifically to offer opinions and look for those issues, was sufficient to provide probable cause for the arrest. So I would submit that that's as far as the court needs to go. There is a couple of additional legal issues. There was a question, I can't remember which of you judges asked that, but whether or not qualified immunity was raised. Qualified immunity was raised by all of the individual defendants, including my three sheriff's deputies. Ultimately, the district court didn't reach that issue. It was reasserted again on reconsideration. Again, she did not find it necessary to reach that issue, but we've raised it as an additional sustaining ground since obviously this court has the ability to decide cases on whatever ground may appear in the record. But qualified immunity was argued below. And quite frankly, if those historical facts that I've just outlined do not create probable cause, and I certainly think they do, it is certainly not without dispute under the qualified immunity standard that those historical facts would not lead a reasonable officer to believe that he or she has probable cause. In the Orem versus Gilmore case, this court cited an Eighth Circuit case talking about arguable probable cause. That's a concept that a number of other circuits have recognized. In the Orem case in 2020, this court also recognized that as well. And clearly in this particular case, if those historical facts as I've outlined do not give rise to probable cause, they certainly give rise to arguable probable cause, and qualified immunity should be granted as to the individual officers. Lastly, just touching on this issue dealing with the confession itself, one of the legal issues that has arisen is whether or not the exclusionary rule even has any application in Section 1983 cases. There is a number of cases from other circuits as well as from the U.S. Supreme Court in the Pennsylvania Board of Probation and Parole versus Scott case, where the Supreme Court has declined to extend the exclusionary rule to any proceedings other than criminal proceedings. The Fifth Circuit, the Second Circuit, and the Ninth Circuit have also, and the 11th Circuit, we've cited all these cases in our brief, have also refused to apply the exclusionary rule in non-criminal contexts, including Section 1983 cases.
Well, let me ask you on that. Why would anybody have to get into that in this case where he made the same statement before the in court on the probable cause hearing?
Well, I agree with you, Your Honor.
Identical. His statement was almost identical, and it was made under oath before a court.
That's correct. And it was actually more than a year later, it was in family court, and he did make the exact same statement that constitutes the confession under oath before the family court as part of the DSS proceedings.
And that can certainly come in, couldn't it?
Well, that certainly supports the finding of probable cause. Absolutely. It also supports.
Well, that supports
qualified immunity issue.
That supports probable cause to from that point on. But,
right.
The argument that Michael makes is that his arrest wasn't supported. And you have a two-pronged response. You're saying the evidence was sufficient, number one, and number two, the officer had qualified immunity in any event in those circumstances.
That's correct. And then a third argument that you don't necessarily have to reach, but that under the exclusionary rule, and that includes the exclusionary rule under Miranda, is not applicable in a 1983 case to exclude the confession itself. And ultimately, that was an additional ruling by the district court in this case. Ultimately, Your Honors, that triggers, of course, this Gilliam case that this court issued its decision on in 2019, which is obviously the principal case that the appellants rely on. And in the Gilliam case, this court did not consider, and I'm assuming it was not raised to the court, that the exclusionary rule is not applicable in a Section 1983 case. In addition, there is a previous precedent from this court, the Burrell versus Virginia case from 2005, which does not expressly decide the question of whether the exclusionary rule applies or not, but it does implicitly discuss that, because in that particular case, there was the argument that the motorist in that case didn't want to turn over his insurance card when he was pulled for failure to, during a traffic stop, and failed to provide proof of insurance. he claimed that he had a Fifth Amendment right against self-incrimination. This court ultimately found that that did not apply, relying on the Chavis versus Martinez case from the U.S. Supreme Court, and finding that the Miranda exclusionary rule only applies when there's an attempt to use coerced or involuntary testimony in a criminal trial itself, the trial itself. And ultimately,
Well, to take that principle on a little bit, it would be sort of strange in a civil case, a 1983 case, to allow evidence to come in where the evidence was obtained by a shotgun held to a man's head and a knife at his throat, and he signed a confession. I mean, it goes to possibly to the legitimacy of the evidence, whether it was real evidence or not. I'm not sure we have to take that principle all the way, but the danger of your argument leads there.
can I have 30 seconds to address
Yes,
that real quick?
please.
I think Judge Niemeyer, I've given that a great deal of thought, and I think probably where the distinction lies, and I understand the Gilliam case involved both fabricated and coerced confession. And this particular case, of course, there's no allegation of anything being fabricated. I think the distinction really should be, if something is fabricated, it's obviously false evidence, and false evidence can't be relied on to establish probable cause. I mean, that's well established in Franks v. Delaware and numerous cases since Franks. But there's a difference, I think, where the officers are simply being alleged. Number one, in this case, they did give Mr. Livingston his Miranda rights. What at least in the suppression hearing, the state judge was critical of is that they didn't give him his Miranda rights again after he didn't reach an attorney and then decided to start confessing or providing an explanation, that he should have been Mirandized again at that point. And then there's also the question in this case as to whether or not the interrogation technique of talking about what further procedures they would follow, such as interviewing the wife and potentially interviewing the daughter, whether that was an appropriate interrogation technique. So you have a situation that's a good bit different, of course, than Gilliam, where you had an absolutely fabricated confession, and you were, of course, dealing with individuals with significant intellectual disabilities, which, of course, we don't have here either. So I think that's where the court could raise a distinction, or you can reach that issue. I don't believe you need to reach that issue.
All right,
I would
thank
ask
you.
the court, please affirm the court below. Thank you.
Thank you. Mr. Gessner?
Yes, Your Honor. Good morning. Evan Gessner on behalf of DSS. May it please the court. I think everything regarding probable cause has been argued very well by Mr. Lindeman, so I'm just going to touch on how all this affects DSS. With respect to Michael Livingston's written confession, I think Gilliam is inapplicable, and I think that written confession can absolutely be used in the probable cause analysis. One key piece of the Gilliam case was the fact that the officers knew the confession had been coerced and fabricated, and therefore they can't rely on a knowing false confession to establish probable cause. Here, no one at DSS had any knowledge about the circumstances of Mr. Livingston's confession. They were not present for the interrogation. They had no knowledge of how it was obtained. DSS was simply told that Michael Livingston confessed. They were given a copy of the confession, and they knew that Michael Livingston had been charged. So from DSS's standpoint, in addition to all the other pieces of evidence that established probable cause, I think unquestioningly the written confession comes in. With respect to DSS, plaintiffs or appellants' claims against them are a little bit different because they do raise a claim for Heather Livingston with respect to the Child Protective Services investigation and the family court action against her. I would point out that Michael Livingston, in his written confession, stated that Heather had witnessed him abusing the children and didn't do anything to stop him or alert authorities. That would clearly give DSS probable cause to believe that Heather Livingston had neglected or abused the children. And that's in addition to all the other elements regarding the severe injuries to the children, the fact that Heather and Michael were the only individuals that had access to the children, and the lack of any explanation by them as to how these injuries occurred. I would point out that appellants in their argument simply point to the pieces of evidence they believe shows their clients were innocent, while ignoring all the evidence that implicates their guilt. Now, a probable cause analysis requires a totality of the circumstances, and it does not require that every piece of evidence be fully run down and that there be a credibility determination. It's simply an analysis as to whether or not the prosecuting entity had reasonable belief that a crime had been committed. And I think all the evidence that's been presented in this case, and it's in our briefs in the appendix, Mr. Lindeman went through it quite thoroughly. The only conclusion is that there was probable cause for DSS to maintain the family court action against Michael and Heather Livingston. We also, on behalf of DSS, there's an additional sustaining ground that was not ruled upon by the district court, that the only claim against DSS is a state tort malicious prosecution claim. In South Carolina, we have the Tort Claims Act, which covers DSS as a state agency. The Tort Claims Act contains an immunity for state agencies for any claim that arises out of the initiation or prosecution of any judicial or administrative proceeding. So I think that grant of immunity would apply irrespective of anything else. Appellants mention in their brief two pieces of evidence that I would argue is wholly irrelevant. They refer to comments made by one DSS attorney and some allegedly racist comments made by a DSS caseworker. But I think those are wholly irrelevant here. They have nothing to do with whether or not probable cause might exist. And consequently, I think the district court got it right. The grant of summary judgment was entirely proper, and I would ask that this court affirm the district court's holdings.
All right, thank you. Mr. Richter, you have some rebuttal? I think you have to unmute.
Yes, thank you, Your Honor. Yeah, I think it's important to remember the backdrop of this entire analysis is Rule 56. So when this came to the court's attention, it came as a 56. Obviously, in a 56, the standard is that the facts and inferences are interpreted in favor of the non-moving party. It's in that context that, yes, we talk about the facts, and it's especially important because it is a totality of the circumstances analysis. And so there are a couple of important facts that were omitted by my colleagues. There is evidence that the confession was not simply coerced, it was fabricated. And that evidence is the testimony in the record was that when Michael Livingston finally decided to fall on the sword for his family to protect his wife and his child from criminal prosecution or interrogation, and when he first explained the injuries and trying to take the blame, his account of what happened didn't match the injuries. And so his story was shaped with these officers to try to match the injuries that the children suffered. And it's through this process that they developed this coerced confession that matched his alleged conduct to the injuries that were suffered by the children. I think there's some place in there where someone says, well, that doesn't make any sense. It couldn't have happened that way. So tell me another way. And so ultimately they came up with the idea that Michael had handled the children too roughly, maybe squeezed them too tightly around the chest. Maybe the child arced his head back while Michael was holding the child and struck his head on the knee. And that is not just a coerced confession, but it's fabricated to try to match the evidence as the officers understood it to the injuries that the children appear to have suffered from. I don't know how Gilliam could be more on point than in this case, except that our case is better than Gilliam. In the Gilliam case, the opinion.
Let me ask you this. I don't understand the full significance of this, but it keeps bothering me because the statement that Michael said to the court He said, I am solely responsible for the injuries of these two boys. There's no way that Heather could have done it, etc. I would get frustrated and cause those injuries myself. I can guarantee you that during any investigation, there will not be any evidence to show that Heather would cause it. So he's explaining, he said it was out of his control of his frustration that those injuries were caused. Now he's telling that to the court under oath.
Yes, Your Honor.
And it seems to me to say that that's fabricated because he said the same thing before the officers in a situation where he didn't get his constitutional rights honored I'm having a hard time coming to grips with how I handle that.
Your Honor, I think how we handle that is, first, it was not evidence that existed at the time of the arrest. Second,
no, but you keep arguing that it was totally fabricated, trying to bring it under Gilliam.
Yes, Your Honor.
And the fact that he ratifies it and states it under oath in court is hardly indicative of the fact that the earlier statement was fabricated.
Your Honor, and those are facts in dispute that a fact finder someday would.
Well, what's disputed? I'm reading right here from the transcript, and he's in court, and he's saying, I take responsibility for it. I was frustrated at the children and probably caused those injuries.
Well, Your Honor, the dispute, the debate then is he is still trying to protect his family. Subsequent to this, the family is medically examined.
I know his motive may be that, but are you saying he testified falsely in family court?
Yes, he subsequently recanted that testimony, and a jury someday would have to wrestle with.
But isn't that something that is not linked to the coercive? In other words, this was not coerced, what he said. He can recant, and that can be measured later by somebody.
Yes.
It is to say that his statement that he took was fabricated by the sheriffs. It's fabricated by him, maybe, in order to get his wife off, but it is real evidence that can be assessed, evaluated, weighed, and looked at.
Your Honor, I have to keep coming back to the point. It was not there at the time of the arrest. Yes, I agree with you. It is a fact in the record that someday a judge or jury is going to have to wrestle with.
I'm not talking about admission. I'm talking about now. You're not comprehending my difficulty. My difficulty is you talk about the confession before the sheriffs being fabricated as if they caused that to happen.
Yes.
Now, your explanation is he fabricated it, not the sheriffs, and he fabricated it to exculpate his wife. But the question is, then that's not linked to the sheriffs because later he gives the very same statement in court under oath before a judge and says the same thing. Now, maybe that was fabricated too, but it was fabricated by Michael, not by the sheriffs. They didn't testify then.
Yes, Your Honor. What I'm saying is that in the context of that interrogation, the officers shaped that statement so that his account fit the injuries. And yes, under oath in front of a subsequent judge, he repeated that story before he subsequently recanted it. Those are the facts. But again, it's a summary judgment standard. It's a totality of the circumstances. There is evidence in the record that the confession was not simply coerced. It was fabricated, it was shaped, it was manipulated. In the Gilliam case, a distinguishing factor is there was an effort to suppress the confessions in Gilliam, and the state court would not suppress those confessions. In this case, after a full evidentiary hearing, a state court judge, hearing all the facts and circumstances, suppressed that confession as being violative of Michael Livingston's constitutional rights. I'm not saying that's preclusive, but I'm saying that is also a fact in the record. It is a fact that the state court judge.
What I don't understand is, suppose we exclude that statement and determine here whether there was probable cause. We don't look at it. We don't consider it.
Yes.
There's nothing wrong with that, right?
There's nothing wrong with that. And that's where I would urge your honors to see that minimally is a factually rich record about what probable cause existed or what did not. And the facts and the circumstance indicate.
Well, there isn't, if we exclude that we know that the record, you don't disagree with anything else that has been put forth with respect to probable cause. We look just at that evidence, not the confession, not the statement, and see if there was or was not probable cause.
I think that's proper analysis. And I think in a summary
Right.
judgment standard, there are facts in dispute that would prevent someone saying as a matter of law that probable cause existed independent of that coerced confession.
Okay, I understand your position. Thank you.
And what fact was disputed at the time probable cause was needed? In other words, we had two doctors giving opinions that indicated that this was not accidental, it was deliberate. And we have two children showing injuries. That's all true. And we have evidence that indicates who the caregivers were. That's true. What fact is disputed on the probable cause issue?
Well, Judge Childs, in her first order denying summary judgment, looked at those very same facts and distinguished this case from the State versus Smith case.
No, I want to know what the facts are disputed. I'm not going to another case. In other words, what facts leading up to the probable cause facts recited by your colleague there? Which ones were disputed?
The facts are that the children were 5 weeks old. That the
What? I'm sorry, the what? I didn't hear you.
The children are 5 weeks old. The injuries are both old and new. The only thing the medical testing confirmed, at least at the time, was the fact of an injury. And the only thing Lou Roth added was her opinion.
No, it was old and new injuries. Old and new injuries.
Correct, old and new injuries. That's what the medical testing confirmed.
Both children.
Correct.
And there was opinion evidence that they were not accidental.
Yes,
Right.
there was a medical opinion that it appeared non-accidental.
And there was a child expert that said that that in her view, that it had been inflicted. There were two experts, right?
It doesn't lead to the inescapable conclusion as a matter of law that therefore it must have been caused by the parents.
I understand that. We're just channeling up what evidence there was besides, I thought that's what Judge Niemeyer asked you. Your colleague on the other side talked about evidence exclusive of the confession or the statements by Mr. Livingston. And we're just asking you to say what those are. But
Well,
do you disagree with anything your colleague said existed separate and apart from the confession by Mr. Livingston? Now, I understand you say they don't come up to probable cause, but do you say they are disputed or they do not exist?
I say, Your Honor, yes, those facts exist, and many more facts exist under the totality of circumstances that lead us to a factual inquiry ultimately, and that it's impossible to say as a matter of law.
That's what I'm trying to find out. What is the factual dispute about
what are
those
the disputed facts, the facts on the other side?
Right.
The facts on the other side are that the first time the children were medically examined, it revealed nothing. The first time it revealed nothing. The first time they're examined.
Okay.
The first time DSS and the police show up to the hospital, they take no action.
Do you dispute the fact that when they took the scans, they saw broken bones?
No, sir. No, sir.
Well, what's that got to do with the dispute? That doesn't dispute anything.
Well, it's also a fact that when the injuries were discovered in Jackson and Michael was asked, would you bring Joey for an examination? He brought the child immediately, which does not appear to be the actions of a guilty man, knowing that he's abused the children. So there are many other facts.
Well, tell us your three best contrary facts.
The contrary facts
those three don't do it for me. So,
well, Your Honor, much of the evidence is in the absence of evidence. It's the conclusion that because the parents can't give a plausible explanation for the injuries, they therefore must be responsible for them. We reject that. This is summary judgment. That's evidence that's exculpatory of them. That's not evidence that points to their guilt, that they can't explain how their children are hurt. But in the court's order, they ultimately look at that as if you're guilty unless proven innocent. I mean, that seems to be the point of view that poisoned the whole examination.
Actually, I thought the only question was there sufficient evidence at that time for the public officials to conclude there's probable cause that there was abuse going on?
Your Honor,
and the question is, and the evidence that supported that conclusion, surely they didn't have all the evidence because you don't ever have all the evidence, but they had evidence indicative of what they rationally believed, that's their point of view, was sufficient to say probable cause that abuse was occurred.
Your Honor, I respectfully submit
And my question really was, what fact that was advanced to support that is disputed?
well, it is a fact that that medical evidence did not result in any arrest. It is a fact that no arrest occurred until there was a coerced confession. It is a fact that Heather was investigated, Heather was interrogated, and no action was taken against Heather. It's a fact that the officer said that had they not obtained a confession, they would have undertaken a thorough investigation. Those things did not happen. If that evidence had been sufficient at the hospital, they would have been arrested right there in the hospital. That did not happen.
What's wrong with seeking more evidence, finding out a further explanation, filling in the facts, filling in open questions? That doesn't mean that the facts that they had didn't. I think your argument has to be those facts didn't amount to probable cause. I don't think you're disputing those facts. I think you're saying the facts they had before the confession were insufficient to justify a finding of probable cause.
Yes, sir, Your Honor, I am saying that.
Okay.
Yes, sir. Thank you.
All right,
Thank you for
thank
the
you.
additional time you afforded us.
Thank you. This is a serious case, and it's one of those things. They suffered. There's no question about it. The ending is nice that they are together apparently now, and I don't know if that's totally redemptive, but it's better than other alternatives too. All right, thank you very much. What we'll do, I want to say that we would normally come down and shake your hands. Obviously, we can't do that, but we do greet you and thank you for your arguments and welcome you back to the court another time. We'll take a 5-minute recess and then proceed on to the next case.
Thank you, Your Honor.
Thank you, Your Honor.
Judge Niemeyer? Judge Niemeyer?
Marlowe versus Warden. And Mr. Gordon, why don't we start with you?
Yes, Your Honor. Thank you. May it please the court, counsel, my name is Jeremy Gordon, and I represent the appellant in this case, Mr. Patrick Marlowe. This is an appeal from the denial and dismissal of a 2241. Mr. Marlowe was found guilty of violation of civil rights where death resulted and was sentenced to life on one of those counts. On 2241, the magistrate put forth a report and recommendation in favor of Marlowe, and that was overruled by the district court. Our position today is twofold. Our position, first of all, is that the district court made an error in applying an actual innocence test to the savings clause with regard to 2241s. And our second point is that the jury instructions here did not comport with Burrage versus United States, and that the district court made an error with regards to that. Now, in the past few days, I did speak to my colleague from the other side, and at that time there was an indication that the government might not talk a lot about the actual innocence test portion with regards to this case. And if that's, but I'm still at the court service, and I still would like to briefly touch on that. The district court, in overruling the report and recommendation, indicated that there should be an actual innocence case that should be applied to this 2241 with regards to the savings clause. Now, in Hahn versus Mosley, the Fourth Circuit indicated that you use the substantive law of the district of conviction, which in this case would be the Sixth Circuit, and you use the procedural law of the Fourth Circuit, which is the district where the 2255 is out of. But furthermore, in Hahn versus Mosley, the Fourth Circuit indicated that actual innocence is not a part of a 2241 analysis, and it's not part of a savings clause analysis. Furthermore, we know that actual innocence is a procedural requirement, not a substantive requirement. In a Sixth Circuit case that we explained in our brief, Wooten versus Colley, the court indicated that because the petitioner could not prove that he was actually innocent, then the court did not have the jurisdiction to grant him 2241 relief. And the key phrase there is that the party did not have jurisdiction. And I would submit to the court that the fact that they stated that they did not have jurisdiction shows even further that it's a procedural requirement, actual innocence is, as opposed to a substantive requirement. And I will be available at the end of this if the court has further questions on that. But I'd like to move on to the second part of our brief, that is that the district court erred when the district court found that the jury instructions in this case were appropriate, which would go. Let me go back to something a little more preliminary. Is barrage applicable at all? In other words, you have to demonstrate that barrage controls this case, right? Yes, Your Honor, we do. Our position, first of all, is that we know that because Sixth Circuit law is applicable, Sixth Circuit substantive law is applicable, and because barrage was held retroactively in the case of OB versus United States. No, my point is a little different. My question is, barrage dealt with a statute, 21 U.S.C. section 841. And what we have here is section 242. Now, the language is similar, but barrage has not been extended beyond 841 to any other case, has it? So, not by the Supreme Court. And how about our court? Not to, there are cases where I'm asking about our court. Is there any, we haven't extended either, have we? That is correct. That is correct. There's no, that to my knowledge, there's no case that is on the books that indicates that barrage would be extended to this court. And that is why we look to the substantive law of the Sixth Circuit. Because the Sixth Circuit's substantive law is what is applicable here, then we use the Sixth Circuit substantive law, and it's our position that that includes the retroactivity of barrage to the case that we have before.
I'm not arguing about the retroactivity. I'm arguing about the scope of barrage. Barrage has not addressed a different statute, similar language in a different statute. But we don't have any case that has construed the language in 242, have we?
There was not in what I found, Your Honor, no. But
and so the district court in this case was applying death results under section 242 in the instructions and essentially gave a proximate cause type of instruction, right?
Yes, the district court indicated that the district court engaged in a foreseeability, explained in their ruling that, or in their jury instructions, that it was going to be a foreseeability. As I will get to further in the brief, I don't believe, but it's our position that that does not meet the proximate cause standard with regards to the jury instruction. But
it's actually broader. The jury would have to find more under the district court's instruction than barrage would have required if it applied. Barrage did but-for test, right?
Barrage did do but-for.
And the district court did roughly approximate cause test.
The district court, in a portion of it's fair to say, it is true that the district court said that the government need only prove that bodily injury or death was a natural or foreseeable result of the defendant's conduct. So that goes
is that wrong? That sounds to me, there's nothing wrong with that, is there?
That portion in and of itself it explains foreseeability and explains that portion. But the court did not just stop there, Your Honor. The court went on to say, the government does not need to prove that a defendant intended to cause bodily injury or death, or that a defendant's acts were the direct, immediate, or sole cause of bodily injury or death. Now, those things it's our position, Your Honor, that those things cannot be viewed separate from each other. Those things cannot be viewed in a vacuum. Our position is that when the jury was instructed on that whole position and on that whole paragraph, that was error, because and it was error for several reasons. But it does not comport to barrage, and it definitely does not comport to Martinez or Hancock, which are in the government's brief. And Martinez.
Mr. Gordon, this is Judge Rushing. Can I ask an maybe even more preliminary question about this? And it's at the time of the trial, at the time of these jury instructions, did the settled law of the Sixth Circuit sanction these instructions or forbid the barrage argument? The Martinez case out of the Sixth Circuit specifically says that court has not interpreted the results in death language in 242. So was your client prohibited from raising this argument at the trial? I'm having trouble finding where the settled law of the Sixth Circuit sanctioned these instructions, even if they were erroneous, as you contend.
Your Honor, it's our position that the settled law, that it was settled law because of the law of the case theory. Mr. Marlowe had a trial. Mr. Marlowe had an appeal. Mr. Marlowe had a 2255. All of those things well before barrage. So it's our position that when we look at all of those things, that the legality of the sentence was well set.
So I must have missed that. Did he raise this issue at all of those stages and was denied?
I do not believe so. I can go back and review. I can go back and review and supplement, but I do not believe so.
So if he didn't raise it in a court, no court told him, we disagree with that argument, and no one ever raised barrage, and the Sixth Circuit law never foreclosed it. No, the Sixth Circuit law never suggested that this was not a requirement. Then how can I find that the settled law of the circuit was to the contrary.
Well, it's our position that if it wasn't a settled law at the time, then it would have been something that would have been something that would have been brought up on either direct appeal or on 2255.
Okay.
And it is something that I can go and supplement, or I'll review, and it'll be something I can bring up on my rebuttal.
Yeah, I'm just asking because, you know, whether this is a Jones analysis or a Wheeler analysis, that's the first question, is whether the settled law was to the contrary originally. And usually in those cases, we have an opinion from the court that says, you know, we interpret the statute one way, and then you have an intervening decision that says, no, we interpret it the other way. And so settled law is pretty clear, but here, no one's really pointed us to settled law that would point the other way.
That is something that I would ask to be able to supplement with, and something that I would review while my colleague from the other side is presenting. All right. So if there's no more questions for me on that, I'd like to go on to any other topics that the court would like to discuss.
Well, you understand that that's pretty fundamental, right?
I do understand. Yes, Your Honor.
Okay.
Well, based on that, I would like to yield the rest of my time.
All right. Thank you, Mr. Gordon. Mr. Lee?
May it please the court, Jason Lee on behalf of the warden. For multiple reasons, this court should affirm the district court's denial of Marlowe's second habeas petition. First, as Judge Rushing and Judge Motz just alluded to, this court lacks jurisdiction over Marlowe's petition because he could have raised this challenge to his conviction earlier in his direct appeal or on his first habeas petition. There was no case law that rendered such a challenge futile. Because he could have raised this challenge before, he cannot do so now. Second, even if there were jurisdiction, Marlowe's challenge necessarily fails on its merits because the jury instructions used at trial sufficed under barrage. Third, even if the jury instructions were insufficient, that error was nonetheless harmless because the evidence at trial was uncontested that had Marlowe provided medical care earlier, death would not have resulted. Affirmance is required at every stage of this court's analysis. I'm happy to answer any questions about any of these points, but let me take them each in turn. Starting first with jurisdiction, I'd like to focus, as Judge Rushing did, on this court's decision in In re Jones and the points raised on pages 16 and 17 of the government's brief. Under In re Jones, which applies here because Marlowe is challenging his conviction and the jury's finding under 18 USC section 242, Marlowe must show that he was foreclosed from challenging his conviction because of binding case law that at the time of his direct appeal and first habeas petition, that the death results language in section 242 can be satisfied without but for causation. And for the reasons that Judge Rushing alluded to, Marlowe cannot make this showing because the issue of the requisite level of causation under section 242 was an open legal question in the Sixth Circuit at the time. Marlowe was convicted in 2006. He filed an unsuccessful appeal of his sentence in 2007. He filed his first habeas petition in 2009, alleging ineffective assistance of counsel. That same year, the Sixth Circuit in United States v. Martinez made clear that it had never interpreted the death results language in section 242. This meant that at the time of Marlowe's first habeas petition, there was no binding case law on the level of causation one way or another, because Marlowe therefore could have raised this challenge earlier. And because he could have raised this challenge earlier, he cannot do so now under the savings clause in a second habeas petition. And I think this is made clear based on the many cases this court has issued regarding the savings clause. Starting with In re Jones and following, the thrust of those cases is, hey, if you didn't challenge your conviction earlier because during your direct appeal or your first habeas proceeding, it would have been futile under then governing law, then we'll excuse that failure and we'll let you bring that challenge to your conviction years later if the law subsequently changes and that change is held to be retroactive on appeal. But the counterpoint to that is where you had an opportunity to raise that challenge earlier, where the petitioner had, as this court has termed it, an unobstructed procedural shot. Where the prisoner had an unobstructed procedural shot to raise that challenge earlier, that we won't excuse. We won't let you raise that challenge years later, such as here, where the second habeas petition was filed 11 years after conviction and in an entirely different circuit. This is a high bar, but we're talking about statutory retroactivity, and by design, the savings clause erects a high bar. The savings clause specifically requires that the prisoner's original Section 2255 remedy be inadequate or ineffective to test the legality of detention. Under In re Jones, construing that savings clause, at footnote 3, this court noted that the savings clause operates for prisoners who, through no fault of their own, lack a source of redress. Here, that does not apply to Mr. Marlowe. Marlowe had a source of redress, and that was his direct appeal and his first habeas proceeding. And indeed, the Sixth Circuit has made this a pretty straightforward case regarding jurisdiction, or as it turns out, the lack thereof. This is not a case where this court needs to parse another circuit's law and figure out what this precedent stands for, how far this other opinion may extend. Rather, what we have here is a direct statement by the Sixth Circuit, issued the same year as Marlowe's first habeas petition, stating that we have never interpreted the death results language under Section 242. What that means is Marlowe was free to raise this challenge earlier. He was not foreclosed in any way. Such a challenge was not, in the words of In re Jones, futile. He had it available to him, and thus he fails the first In re Jones factor. As a consequence, he also fails the second In re Jones factor, which requires a subsequent change in the law. But again, because the level of causation required under Section 242 was an open legal question in the Sixth Circuit at the time, barrage did not affect any change. Indeed, there cannot be a change in the law if there was nothing to change. And here, there was nothing to change because there was no binding circuit precedent that foreclosed Marlowe's current challenge, having been brought earlier on his direct appeal or in his first habeas petition. And for that reason, this court lacks jurisdiction over his second habeas petition. But even if there were jurisdiction, it's clear that Marlowe's challenge fails on its merits. Marlowe asserts that the jury could not find but-for causation because under the jury instructions, the jury was told that the government did not need to prove that Marlowe's conduct was the immediate, direct, or sole cause of Kuntz's death. In Marlowe's view, that meant the jury could not find but-for causation. But this is a misunderstanding of but-for causation, because a but-for cause does not need to be immediate or direct or the sole cause of a result. Indeed, the irony here is that barrage, the case on which Marlowe relies for jurisdiction, dooms his challenge on the merits. Writing for a unanimous court in barrage, Justice Scalia offered the following example of but-for causation. A baseball game where the leadoff batter hits a home run and that team wins by a 1-0 score. Now that leadoff home run is a but-for cause of the team's victory, even though it's not an immediate cause of victory Indeed, there were 9 more innings left to play. It was not a direct cause of victory. The team was not instantly made victorious, and it was not the sole cause of victory. As Justice Scalia noted, there could be other but-for causes of the victory, such as skillful pitching. And indeed, the Supreme Court just last term in Bostock, in an opinion authored by Justice Gorsuch, noted that there can be multiple but-for causes for a single outcome. So here, it's clear that the jury instructions complied with barrage. Moreover, it's clear that that Marlowe's challenge is foreclosed under Sixth Circuit law. And here I'm referencing the United States v. Martinez order that was attached to our second 28J letter. In that order, the Sixth Circuit affirmed a district court holding that where evidence is sufficient to support a finding of proximate cause, it de facto suffices for a finding of but-for causation. And here I would like to refer to Judge Niemeyer's comments earlier. We agree that the jury instructions did require the jury to find proximate cause. We said that specifically on page 20 of our brief, and Marlowe does not dispute that. So here we had a finding of proximate cause by the jury. Applying Martinez to these set of facts, it's clear that because the jury therefore found proximate cause under Martinez, that should suffice for any necessary finding by the jury of but-for causation. So that's an alternative basis on which to find that Marlowe's claim fails on the merits, because they were required to find proximate cause, that suffices to find but-for causation. But even beyond that, we believe a plain textual argument and analysis of the jury instructions shows that the jury was required to find but-for causation. The jury instructions referenced the natural and proximate result of Marlowe's actions. By using the term result, that led the jury and required the jury to apply the ordinary common sense meaning of the word result, which under barrage incorporates a finding of but-for causation. So therefore, even looking at the text of the jury instructions, the jury was required to find both proximate cause and but-for causation. And we know that they did. And we can tell based on the jury's verdicts on count 2 versus count 3. In count 2, the jury found that Marlowe's assaults of Walter Kuntz resulted in bodily injury, but not death. But in count 3, the jury found that Marlowe's failure to provide medical care resulted in both bodily injury and death. So what we have here is a considered judgment by the jury in which they differentiated between different consequences of different sets of action by Marlowe. And what they found was the straw that broke the camel's back, the conduct that cost Walter Kuntz his life, was the failure to provide medical care. And so for these reasons, there's no jurisdiction over Marlowe's petition because he could have brought this challenge earlier. And the jury instructions sufficed under Burrage, meaning that Marlowe's challenge fails on its merits. But even if there was an error in the jury instructions, there was uncontested evidence at trial that the failure to provide medical care there was uncontested evidence at trial that it was the failure to provide medical care that resulted in Walter Kuntz's death. All parties agreed that Walter Kuntz had a treatable medical condition. That was attested to by the government's 3 experts. It was also attested to by Marlowe's expert. Everyone agreed that the subdural hematoma that Walter Kuntz had was a treatable medical condition. However, the attending neurosurgeon that attempted to provide medical care for Walter Kuntz testified that by the time Walter Kuntz arrived in his hospital, he was, quote, well beyond the point of saving. Marlowe did not provide any evidence at trial that Walter Kuntz would have died even if medical care had been provided earlier. The only evidence was that medical care could have saved Walter Kuntz and it was not provided earlier. Indeed, it was 5.5 hours after Walter Kuntz started exhibiting symptoms, that EMTs arrived on the scene. But even then, Marlowe he was not candid with the EMTs about what had happened. He did not tell EMTs that Kuntz had suffered a head injury. And so EMTs arrived on the scene believing this to be a case of alcohol poisoning. Indeed, one of the EMTs testified that had they known about the head injury, they would have airlifted Walter Kuntz to a trauma center instead of taking him to a local medical center. And so what's clear from the evidence before the jury is that at the very least, Marlowe's failure to provide medical care was at least one but-for cause of Kuntz's death. And that is all the jury was required to find, applying a but-for cause analysis. So for those three reasons, we believe that the district court should be affirmed here. There is no jurisdiction because Marlowe could have raised this challenge earlier on his direct appeal or his first habeas petition. Even if there was jurisdiction, the claim fails on its merits, including under barrage. And even if there was error in the jury instructions, based on the uncontested evidence of causation before the jury, any error would have been harmless. I'm happy to answer any questions from the panel, but if there are none, I can rest.
Thank you, Mr. Lee.
Thank you.
Mr. Gordon?
Your Honor, based on what's happened here, I would ask for the opportunity to supplement my briefs with the court and provide further legal information.
On what?
On the issues of the first prong of the savings clause test.
What do you want to submit?
Any law that exists or that I can find that indicates that settled law of this circuit had established the legality of a sentence.
Well, your colleague on the other side offered us 3 reasons why we should affirm. So if any one of those was correct, we would affirm, right?
Yes, Your Honor, that's correct.
Well, you wanted to take time to address one of them.
Yes.
You're prepared to rest on whatever you've said with respect to the others.
I mean, no, Your Honor, I'm not. I'd like to bring forth the information. I'd like to bring forth the rest of what I have to say, but as the court indicated, the first thing is highly important and
well, all the points are important. The real question is, you're making an unusual request. I mean, we're very generous on giving requests, but the briefing was a straightforward briefing. You have to come under the savings clause. That's the whole basis for your being in court, because this is your second petition, and you want to re-brief that? Is that?
All right. Well, I can go on to the other issues that were brought up. I can go on to the issues that were brought up. In our original brief that we brought up in the district court, we indicated how and why we believed that at the time of Marlowe's conviction, the law in the Sixth Circuit did not require a showing of but-for causation in order to support a conviction under 18 U.S.C. 242 when death results was at issue. This was in the briefing that we submitted to the district court and to the district court, and as part of the record on appeal. At that point, that was what the magistrate found that the 2241 should be found to be granted, and that particular thing was not argued by the government at that time. So now position is that's how we meet the first standard. Now, as for the second standard, as for the second test that barrage applies here, our position is that barrage does apply here, and that the jury should have been explained the explicit but-for causation element that was explained in barrage. Our position is that the jury instructions in Martinez do not apply here, because the jury instructions in Martinez, first of all, are better than what Mr. Marlowe received. the jury instructions in Martinez explained that proximate cause would be appropriate, and the jury instructions in that case indicated that that the jury must find that Martinez's fraud is either the proximate or the direct cause of two patients' deaths. But in this case, there is no. It was explained not only that there had to be a foreseeability analysis, but the court also indicated in our case, in the second portion that I read, that the jury was not required to find that the defendant was the sole cause of death, or the direct cause of death. So in our case, unlike the jury instructions in Barrage and unlike the jury instructions in Martinez, we did not get to the we did not get to that. We did not get the same jury instructions. And in regards to Hancock, Hancock indicated that Hancock also did not have the second set of jury instructions. That the defendant did not need to be the sole cause of death. If you're explaining these things to a jury, then you have to be. Then it matters. What matters on both sides is important and appropriate. So it's our position that the jury instructions here did not provide but for causation as to the medical, as to the information, because of what was in the totality of the jury instructions that were read. It was not sufficient under Barrage. So then it's our position that that second portion is met. So then, lastly, the information that so based on those things, it's our position that the appellate court should reverse and send the case back down to the district court, and with instructions to find that the 2241 should be granted.
All right, thank you, Mr. Gordon. We normally would come down and greet you. Are you in Texas, Mr. Gordon?
Yes, sir, I am.
That's going to be a little hard for us to get down and shake your hand, but that's our normal custom. And since we're acting virtually here, we'll greet you both and thank you for your arguments, and we'll proceed on to the next case. Thank you very much.
Thank you.
Thank you, Your Honors.
Thank you.
Court, Judge Niemeyer.
All right. So what we have Mr. Abrams. Is that? Can you hear me?
Yes, Your Honor.
Okay. And Mr. Rogers, can you hear me?
Yes, Your Honor.
Okay. We'll proceed with the United States versus High, and Mr. Abrams, we'll hear from you. Thank you.
Thank you, Your Honor. May it please the court. I'm Elliot Abrams on behalf of the appellant Anthony High. Your Honors, this court has confirmed time and again in the context of resentencing motions that a district court must explain why it rejected a party's post-sentencing mitigation arguments. This court has vacated and remanded for reconsideration in Martin, McDonald, Cooper, Bodie, Greer, McCarson, and Sprague. Here, the district court provided only one paragraph of case-specific reasoning in response to the party's more than 100 pages of argument and exhibits, which provided fully developed, non-frivolous arguments why new post-sentencing circumstances warranted resentencing. In its order, the district court did not make clear that it considered Mr. High's post-sentencing mitigation arguments, nor did it provide any explanation of how the 3553A analysis was affected by Mr. High's vulnerability to serious illness or death from COVID-19. Indeed, the district court never mentioned the pandemic, COVID-19, or Mr. High's significant medical conditions and risk factors, such as serious heart issues, history of smoking, hypertension, and obesity. Nor did the district court mention Mr. High's educational and vocational rehabilitation or his substantial infraction-free period post-sentencing in the BOP. And the court did not explain why it rejected Mr. High's argument that home detention, which was now available for the first time on resentencing, would adequately deter future violations by him. Ultimately, because the district court failed to give individualized attention to each of Mr. High's post-sentencing mitigation arguments, the district court abused its discretion in denying Mr. High's motion, and the order must be vacated and remanded for reconsideration. Although this court has never specifically held by a published opinion that the individualized explanation requirement of Martin, which dealt with 3582C2, similarly applies to the statute at issue here, 3582C1A, this court in McDonald recently applied Martin to a resentencing motion under 3582C1B, and there is no basis for not similarly applying Martin to 3582C1A. Indeed, at oral argument in McDonald, the government conceded that the Martin individualized explanation requirement should apply to section 3582C1B, and there's no logically consistent basis for it failing to similarly concede that Martin applies to section 3582C1A. Mr. High's arguments also triggered the Martin individualized explanation requirements because he presented post-sentencing mitigation arguments that were not available at the time of Mr. High's original sentencing. Mr. High presented not only post-sentencing mitigation in the form of a substantial infraction-free period and the completion of numerous educational and vocational courses in BOP, he also presented a dramatic new circumstance. That is that he presents a high risk of serious illness or death from COVID-19 due to his serious health problems. And he presented that BOP has been unable to adequately control the spread of the virus, thus leaving him exposed to catching a disease that may well kill him. That was a new circumstance that was not before the court at the original sentencing hearing. Mr. High presented that in a fully developed argument to the district court, and the district court did not mention that argument in its order.
Mr. Abram?
Yes.
This is Rushing. Is it your position that the district court was required to address that? The district court decided this issue only on the 3553A factors, and other courts of appeals have said that the court can do that. It doesn't have to address the other prongs, such as whether the pandemic is in this particular prison or whether this person's at risk, but rather the court can just decide based on 3553A because all of these elements are required to be shown. Is it your position that the court had to talk about the other prongs of the analysis?
Your Honor, it is not our position that the court has to address both prongs. I think this court has consistently remanded when courts have not done so, but here our position is that by failing to mention and address Mr. High's his argument that he's a high risk for catching COVID, the court could not conduct a full 3553A analysis. And so the failure to address this argument means that the court's 3553A analysis was incomplete. And under 3553A, there are numerous reasons that the high risk to death or serious illness from a disease that's running through a prison would be relevant. For example, 3553A1 talks about the history and characteristics of the defendant. Certainly, it would be relevant at an initial sentencing if there were some similar circumstance that if someone were sentenced now, for example, it would be relevant to the 3553A analysis that someone is a high risk of catching COVID. There's also 3553A2D, which talks about providing medical care in the most efficient manner. And then 3553A3, which talks about the kinds of sentences available. I think each of those 3553A factors are factors that are implicated by someone who is a high risk of death or serious illness from COVID-19. So our position here is even if you take the government's reading of the order and say that the court assumed without deciding that Mr. High presented extraordinary and compelling reasons for relief, the court nonetheless could not have conducted a fulsome 3553A analysis without giving attention to the high risk that he presents of death or serious illness from COVID-19. And our argument is basic in that point, that when a defendant makes a motion for resentencing and presents new post-sentence mitigation arguments that were not available, the district court has to give those arguments individualized attention and provide this court a way to understand.
Mr. Abrams, how do you distinguish Chavez-Meza?
Your Honor, in Chavez-Meza, the Supreme Court found an intuitive reason for denying the defendant's request that the judge resentence and go all the way to the bottom of the guidelines. Whereas here, there's no intuitive basis for us to say how the court declined to, why the court didn't find Mr. High's argument.
But that doesn't address the circumstance in Meza, which Chavez-Meza, which seems to provide some guidance for here. There, the defendant challenged the sentence and said the court didn't address his courses, his education, his rehabilitation type of thing. And the court merely checked the box on the form, saying that it had considered the 3553, and the Supreme Court said that's fine.
Yes, Your Honor, and I think it was clear from the record that the court did consider those things. The court actually did lower the sentence in Chavez-Meza. It went down from 135 months to 114 months. And so really the dispute was, did the court provide enough to tell us why it didn't go down from 114 to the 108 that the defendant asked for? And so the court said, well, we can look at this record and see that the court originally sentenced this person to 135 months and thought that that was an appropriate sentence. And so we've intuited that from this record, that the court thought somewhere above the bottom of the guidelines, which is what the defendant asked for in Chavez-Meza, was appropriate. And so I think that's the first reason to distinguish Chavez-Meza. The second is what I've already mentioned, and that is that the judge actually did grant some relief in Chavez-Meza. So the court clearly considered—
I'm sorry, I don't understand the difference between your first and second reasons.
And they are very, very much related. The first point is simply that the court said we can intuit why the district court did what it did. And I don't know that that applies here. And then the second basis is that the record shows that the court actually did consider arguments of the defendant about post-sentencing conduct or post-sentencing issues because the court granted some relief. Whereas here, the court didn't grant any relief and didn't make any reference to the fact that Mr. High's situation has dramatically changed. He was sentenced at a time when it was safe for him to be in prison. Now he's in a place that may well kill him, and the court made no reference to that changed circumstance. And then Chavez-Meza was, of course, factors into this court's pre-existing and post-Chavez-Meza case law that says that if for example, in Martin and McDonald, if a defendant raises post-sentencing mitigation arguments, the court must give those arguments individualized attention. And so—
Well, the court, of course, we can't reverse the Supreme Court, right? We might like to sometimes, but that's not within our province. So do you not think maybe those decisions are in conflict with the Supreme Court case? Did you feel like there was, but because there was a change in the sentence, you think that that's evidence of an individualized attention? Is that what you're telling us?
Yes, Your Honor, both that the court intuited from the record the basis. So it looked through the record and said, I can see why you rejected the argument to go all the way down to 108.
No, I understand that, but I'm trying to reconcile it with our our precedent, and we say that there must be an individualized attention, and you're saying, well, what was done in Chavez Mesa shows that there was given an individualized attention. Is that what you're saying?
That's exactly correct, Your Honor. And I think that that Chavez Mesa is not in conflict with the precedent in this circuit, because what Chavez Mesa says is that the court has to provide enough so that appellate courts can to make clear that the court considered the arguments of the defendant. So that's in Chavez Mesa, and then it's just application of that standard that the court says, we've looked at the record, and from this record, it's clear to us that individualized attention was, they didn't use the words individualized attention, but that the district court considered those things. And so I think that the rule is the same, that in all circumstances, the district court has to make clear, and this is from Chavez Mesa, the district court has to make clear that it considered the parties' arguments, and then it found that it had in that particular case. Of course, in that case, we weren't dealing with a pandemic. We were dealing with more regular sentencing factors.
Well, that's what I was about to ask you. Do you think that there is possibly a requirement that there must be in these COVID cases, which aren't going to go on forever, but which are certainly in front of us right now, as a basis for getting this early release, that there has to be some acknowledgement that the court, in the COVID cases, something that's required to acknowledge that that's a special issue?
I think that the COVID cases, the short answer is yes. I think the COVID cases necessarily trigger the individualized explanation requirement and require the judge to just grapple with it and say, because if you are at an initial sentencing and the defendant says, Judge, I'm terrified of going to prison because I think I might die. Look at how high risk I am. This is a new circumstance. If we have a situation where, a high percentage of people are going and getting really sick, that affects the 3553A factors in every case. And so, and fortunately, it's not going to go on forever. So that this is just an application of Martin and McDonald and the cases that say if you present new circumstances to on resentencing, the district court has to give them individualized attention. And of course, the amount of what the district court has to say is probably a pretty low bar, but here there's simply no mention whatsoever of COVID, of his high risk conditions, and therefore no ability for the court to figure out how the district court weighed what was a very real dispute before it, which was whether he's high risk and how significant the risk was that he would actually catch it. We submitted that he was a high risk and that it was not being adequately controlled. The government said he's not a high risk and it is being adequately controlled. And we don't know how the district court resolved that or whether it considered it at all. I see that my time is up, and if there are no questions right now, I'll reserve the balance of my time. Thank you.
All right. Thank you, Mr. Abrams. Mr. Rogers.
Good morning. May it please the court. I'm Joshua Rogers, and I represent the United States. This is a case of a defendant with a serious criminal history, including a murder conviction, who requested compassionate release under 3582 C1A1 after just 2 years in prison, citing his clean disciplinary record, attending some classes, and the desire to escape the risk of contracting COVID. Now, 3582 C1A1 is different, extremely different, as this court recently held in McCoy. McCoy compared the statute to other sentencing reduction statutes and found that the extraordinary and compelling reason standard, quote, captures the truly exceptional cases that fall within no other statutory category. And the reason why that matters is that this statute, in being in a league of its own, its expansive language means that there's an expansive amount of discretion. And the court employed that discretion. It made a finding that it hinged on 3553A, but ultimately it was an extraordinary and compelling finding because that's essentially what the statute asks. The court stated the defendant was very recently sentenced. It's an important finding because defendants must, over time, show that they're worthy of compassionate release. Mitigating evidence minus time is insufficient evidence to assess extraordinariness. So the court noted that. And in saying you were very recently sentenced, the court is noting, I had these facts in front of me, and just now you've been recently sentenced, and I don't have enough information to make this determination, which is supported by the court's statement that the defendant, quote, committed the offense in this action, which involved a gun crime, soon after completing 20 years in state custody for a violent crime. And he is talking about murder and attempted murder with a gun. And now the defendant has been found with a gun doing drug deals. So the court is saying you have a very serious crime. There's been 2 years that you've been in prison. And then the court says something else, that its assessment of the relevant sentencing factors has not changed. The court is again saying, I had an opinion before. I actually did have a sentence before. And now I've seen everything you put in front of me. You have an extremely violent crime on your record. You've got another gun crime. This was very recent. And that's why the court says at the end, the sentence imposed remains sufficient, but not greater than necessary to advance the goals of 3553A. So what the court has in front of it is not your typical sentencing reduction statute. This is one that throws the door wide open for district courts, which is why McCoy has made that abundantly clear, that the policy statement does not actually constrain the district courts anymore. The district courts have the ability to review what they want. They can look at the defendant's desire to avoid contracting COVID or his disciplinary record or anything else he wants to put there. But especially in a circumstance like this, it's particularly easy for this court to look at what the district court did, make a review of what the district court did, and ask itself, is this extraordinary and compelling? The answer is no, it is not. In closing, the defendant did not present extraordinary and compelling reasons. The court had broad discretion under 3582C1A1. It exercised its discretion and it did not abuse it in denying the request. If the court has no further questions, I would ask the court to affirm.
All right, thank you. Mr. Abrams?
Yes, Your Honor. First, the government asked the court to affirm on a ground that was not decided below, and that is whether there are extraordinary or compelling reasons. Indeed, in its briefings, the government suggested that the court assumed without deciding that there were extraordinary and compelling reasons to grant relief. So what we have here, I think, just from these arguments is a lot of different ways to interpret what the court did and a lot of guesswork to be done about what the court did. And that's precisely the point. What we're saying is not that the district court had to rule for us, or just that the court didn't explain why it didn't rule for us, and specifically that it didn't explain why its 3553A analysis was not impacted by the fact that Mr. High submitted that he's likely to get seriously ill or die during custody. There was no attention paid and no explanation for how the court resolved that issue. The issue about being recently sentenced may explain why the court rejected the post-sentencing mitigation presentation about taking courses and staying out of trouble, but it provides no explanation for how the court grappled with Mr. High's high risk of death or serious illness from COVID-19. And so what we have here is a lot of guesswork to be done if we're trying to figure out what the court did. The government's presented multiple different interpretations of the order, some saying that it found extraordinary and compelling reasons, and now it's saying, actually, you can look at this and see that there are no extraordinary and compelling reasons. This is precisely the type of situation where we need to hear from the district court about why it made its ruling. And so, and this is consistent with what this court has been doing in these cases over the last many months, and sending cases back where the court has not addressed parties' arguments. And of course, what we're building off of just long-standing holdings in the Fourth Circuit that in Martin and then now applied in McDonald, and we're asking the court to apply those same argument or that same holding here, that if a defendant presents non-frivolous, fully developed post-sentence arguments then the district court has to give those individualized attention. And the district court did not do that here. And for that reason, we would ask Your Honors to vacate the order and to remand this matter for reconsideration. And if there are no further questions, I'll rest. Thank you so much.
Yeah. Mr. Abrams, were you court appointed?
Yes, Your Honor.
I want to thank you and acknowledge your court appointment on behalf of the court. That's an enormously important service, and you've done a fine job, and thank you very much for that.
Thank you very much.
We would normally come down at this point and greet counsel, and since we can't do that, we're greeting you now and appreciating your arguments, and we'll handle it as best we can without being with you face to face. All right, I'll ask the clerk to adjourn court until tomorrow.
Thank you, Your Honor.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
All right.